And we're back on the Fowler Show, as always, in the Fowler Show, here to inform you, empower you, help you get your voice back. Hit that button below and subscribe. The Supreme Court acted on Monday in the Harris versus Quinn decision, which was a decision about whether or not public employees can be forced to basically pay their fair share, or whatever, pay union due, be forced to pay union dues because the unions bargained for them, or how much it costs for the union to bargain for them. Now, at the heart of this decision was the life and death question of whether or not public unions would be able to sustain their collective bargaining operation and, in essence, themselves. And, you know, the foreshare, the agency fee, which is what it's called in the minutia. The ruling was a very narrow ruling that was done by this court. So this court is basically indicated that rather than, you know, explicitly exempting all public employees from paying their fair share, they've created a new category of worker, a partial public employee, because in the particular Harris v. Quinn, in the case, Harris, the lady, she was a home health worker who was being paid by the state government to take care of her son at home, or being paid by Medicaid to take care of her son. Because the workers are paid by the government, like I said, but hired and fired and managed by an individual client. Alito declared that it is neither it is not fully in the public sphere nor fully in the private sphere. So thus it does not deserve, you know, the fair share protection. Now, there's good news and bad news to this ruling. The good news is that the court, this ruling could have been a lot worse. They could have stripped all public employees of collective bargaining and the ideal of collective bargaining. Now, I think the plaintiff, Ms. Harris, in this particular case, is misguided here. Because if you look at all the statistics, especially in the state of Illinois, when the union came in, which was SEIU in this particular instance, to collectively bargain for the at-home care workers, like Ms. Quinn, right? They got raises, and they got better benefits, and they got more money. But she still didn't want to pay her fair share because these people want to basically have a free lunch. But we already know in America there is no free lunch, and the power of labor unions only happens when our voices are stronger together. They cannot and they will not run over our voices, which is the problem with the Harris v. Quinn decision. It's going to be death by a million paper cuts to labor unions, because more people are going to try to challenge this ideal of collective bargaining. But collective bargaining is what made this country great. Let's never forget that.